First slide, please. So the commencement date for the 2021 amendments to the Defamation Act was the 1st of July 2021. And the transitional provision is Schedule 4, Clause 7 of the Act, which provides that the amendments apply only in relation to the publication of defamatory matter after the commencement of the amendment. And there's a similar provision for the amendments to the Limitation Act dealing with defamation. That has been construed in Barilaro as meaning that the amendments only apply where the cause of action accrues after the commencement date. So if you have a case where defamatory matter was published online before the 1st of July and remains continuously available online after that date, the amendments don't apply. They only apply when the first publication is after the commencement date. So for the rest of this paper, that's what we're assuming. Next slide, please, Jackie. The amendments now provide a prescriptive definition of what a concerns notice is. And it's important to recognise that this is a defined term in the Act. It's defined in Section 4 of the Act, which is the dictionary, by reference to this section, 12A, which provides that for the purpose of the Act, a notice is a concerns notice if it complies with each of those requirements. What that means in practice is that you cannot simply call your letter a concerns notice and have it be so. It actually needs to substantively comply with those requirements. And if it doesn't meet the definition. And so when the Act talks about issuing a concerns notice, it means issuing a concerns notice which does each of those things. There are some form requirements, namely that it be in writing and that it attach a copy of the matter complained of. And there are some substantive requirements, and those are, firstly, that it specifies the location where the matter complained of can be accessed, for example, a web page address. Secondly, that it informs the publisher of the defamatory imputations that the plaintiff considers are or may be carried by the matter complained of. And thirdly, that it informs the publisher of the serious harm that the plaintiff relies on. And if the plaintiff is an aggrieved person, they also have to identify the serious financial loss caused by the publication. Because, as you would know, Section 10A defines serious harm in relation to a corporation as serious financial loss. And you can't simply send a draft statement of claim and call that a concerns notice. That doesn't fly. Could we go to the next slide, please, Jackie? What happens if you are a defendant and you receive a document purporting to be a concerns notice which you think doesn't comply with the requirements? This is dealt with in subsections 3 to 5, which expand on a procedure that already existed before the amendments came into force. The publisher may issue a document which is called a further particulars notice if the concerns notice fails to particularise adequately any of the information that's required. The plaintiff then has a period of 14 days in which to provide reasonable further particulars. And if they don't, and this is the kicker in subsection 5, the plaintiff is deemed not to have issued a concerns notice at all if they fail to do that. Now, you might think as a plaintiff that because subsection 3 starts off by saying if the concerns notice fails to particularise adequately any of the information, you would be entitled to say, well, my concerns notice did particularise that material adequately, so you can stick your further particulars notice. That might theoretically be possible on a construction of the legislation, but I would suggest it's not a good idea. I appeared in a case called Randall and McLaughlin last year where my instructing solicitor effectively did that and responded to a further particulars notice by saying that the answer to the question was self-evident. The judge in the district court held that that wasn't a reasonable response, and the plaintiff was deemed not to have issued a concerns notice as a result, and so the proceedings were summarily dismissed. Even if you think that your concerns notice was immaculate, you are best advised to humour the defendant and answer their questions for what they're worth, lest you be deemed not to have issued a concerns notice. Equally, as a defendant, you might notice the words, "The publisher may give the aggrieved person a written notice," and think, well, I don't have to. I have an election. And you might think that if a plaintiff serves a concerns notice which is obviously defective, you don't want to tell them what the problems are and you don't want to give them a chance to fix it. Again, that is probably an available reading as a matter of statutory construction, but we have obligations as legal practitioners to facilitate just, quick and cheap dispute resolution. The purpose of this whole division of the Defamation Act is to promote non-litigious resolution of cases. And as we'll see, there may be consequences for a publisher who decides that they can't be bothered requesting further particulars. And that may impact how the court treats any later objections to the adequacy of the concerns notice. Next slide, please, Jackie. Now, section 12B is really the crux of the new regime. Provides that a plaintiff cannot commence proceedings unless they've done each of those three things. So first, sorry, Jackie. Firstly, that they've served a concerns notice. Secondly, the imputations that you plead in the statement of claim need to have been particularised in the concerns notice. So any imputation that is pleaded must be in the concerns notice somewhere. And thirdly, you need to allow the applicable period for an offer to make amends to elapse before you commence proceedings. And the applicable period is 28 days. You don't have to rely on every imputation particularised in the concerns notice, and it's okay if you plead something which is substantially the same as what was in the concerns notice. But if you fail to particularise something, you could be locked out of pleading it, and that makes careful drafting of the concerns notices very important. The operative expression in 12B is "cannot commence proceedings." This is an expression which is used in some other statutory contexts, and what it has generally been construed as meaning is that these procedural requirements of giving a concerns notice, pleading the same imputations as you put in the concerns notice and letting the applicable period elapse are mandatory requirements. So if you don't comply with them, it invalidates the proceedings and the proceedings are liable to be summarily dismissed. Next slide, please, Jackie. The other important thing to note about this is the court has no power to cure defects in the concerns notice or excuse non-compliance. It only has this one limited power, which is to allow you to commence proceedings before the applicable period has elapsed in one of two circumstances. Firstly, if you're running the risk of being outside the limitation period, or secondly, if on a general basis, if it's just and reasonable to grant leave. But for anything else, if you failed to issue a concerns notice at all, if your concerns notice wasn't strictly compliant with all of those requirements in 12A, you're stuffed. There's nothing the court can do to allow you to rectify the concerns notice nunc pro tunc or to excuse the non-compliance. If it was non-compliant, the only outcome is that the proceedings will be dismissed. I suppose the other thing to say about 12B is, if we go back to the previous slide, please, Jackie, it's expressed in terms that the plaintiff cannot commence proceedings. So it doesn't expressly say anything, for example, about whether you can commence proceedings only pleading imputations that were in the concerns notice, but then seek leave to amend after you filed your proceedings to introduce new imputations. As far as I'm aware, that hasn't been tested yet. There's a case called Newman and Whittington in the Supreme Court where Justice Rothman allowed a plaintiff to amend the statement of claim to introduce entirely new causes of action, new matters, which weren't in the concerns notice. That, I would respectfully suggest, is a surprising conclusion, and that judgment is under appeal, so I won't say anything more about it. But I think it is likely that a court would permit a plaintiff to amend to introduce new imputations. The striking thing about 12B is how much it constrains the discretion of the court to cure defects and, frankly, to control its own processes. And I think a court would be reluctant to adopt a very broad construction of the scope of that restriction. The court, I think, would be at pains to allow an amendment if the court thought it was just and reasonable to do so, and wouldn't be overly eager to find itself restricted by section 12B. So what I want to move on to now is the section of the paper that begins at paragraph 41, which is how do I write a valid concerns notice as a plaintiff? And a little bit of intellectual humility to start. Everyone is still learning, and given that all of the cases so far, except Newman and Whittington, have been in the district court, there hasn't been any sustained consideration of this in the higher courts. So to some extent, it's all a bit up in the air. But what I want to set out now are what I think are best practice guidelines for doing concerns notices. Some of them are hard requirements, like do this or be damned. Other ones are more in the nature of things you ought to do to make your concerns notice as good as possible. We've already seen that it needs to be in writing, and you can't just serve a draft statement of claim. Ideally, you would identify the letter as a concerns notice under the New South Wales Act, or if it's in another state, the legislation in that state. It won't be fatal if you don't, but I think it's a good thing to do. Similarly, it would be good if the letter is divided into subheadings, which indicate where you're identifying the circumstances of publication, where you're identifying imputations, where you're identifying serious harm. What the court will look at is whether the letter contains information which recognisably answers the requirements in section 12A1. Now, if it recognisably contains that information but you don't have subheadings, it won't be the end of the world. But the subheadings show the court where to look and ensure that relevant material isn't missed. So there's something you should include. Jackie, could you go back a couple of slides? Yeah. Now, the requirement in Roman 2 clearly contemplates online publications primarily. But even if you're dealing with analogue publications, it's good practice, I think, to be as precise as possible about where and when the matter complainant was published. So if you're talking about a newspaper article, I would suggest obviously the day that the newspaper was published on, but also the page of the newspaper that it was published on. If you're talking about a television or radio broadcast, I would suggest giving the time of the broadcast. When it comes to online publications, giving a URL is absolutely essential. And not just the URL of the main page, but the URL of the particular location that this matter was published at. I did a case called Randall and McLaughlin last year where the plaintiff was complaining of material that was posted in a Facebook group, but the only part that was complained of was a single comment in a thread of other comments. I think in a situation like that, what you need to do is give the URL for the comment thread, and then when you attach a copy of the matter complained of to the concerns notice, the best thing to do is physically draw a box around the bit that you're complaining of. Because Judge Gibson was very critical in that case of the imprecision with which the plaintiff had identified where this particular comment was to be found. The drafter of the concerns notice had excerpted the comment and taken it completely out of context, so the recipient of the concerns notice couldn't see that this comment was in fact part of a larger thread. Often matter is published in more than one place as well. You should try to capture every location where it was published. For example, if you have an article in the Sydney Morning Herald, it will be published on smh.com.au. So you need to capture the online publication. Typically, Fairfax or other news outlets will promote the story on their social media channels. You should capture each of the social media posts which promote the story. In many cases, especially if it's a juicy story, the journalist will promote the story as well on their social media accounts. And you should capture all of that and make sure you've got screenshots of it all. When it comes to identifying the matters complained of, an online article and a print article should generally be separate causes of action because they will be different. Even if the text isn't different, the layout, the formatting, the use of pictures and headings will differ, and that can all affect defamatory meaning. So you should identify print and online as separate causes of action, but social media republications of an online article don't need to be separately identified as individual causes of action. You can just rely on them as republications which go to the extent of damages. For God's sake, screenshot everything when it comes to online publications, and not just post itself, but the likes and all of the comments. It makes me very, very sad when I get a brief which contains a social media post which has been screenshotted, and it cuts off the comments and it cuts off the likes and the emoji reactions. That material is very important for a couple of reasons. Firstly, it shows the extent of publication, or indeed the fact that somebody has actually read the thing. Courts won't assume that just because something has been uploaded to social media, somebody has read it. You need to actually prove that fact, and the fact that people have commented on the post or liked the post shows that they've read it. And it can also be really good material for proving serious harm. So often, in media cases in particular, we see a story published and then volumes and volumes of often absolutely vile comments on social media about the plaintiff. This happened in Barilara's case, for instance. Friendly Geordie's uploaded his videos to YouTube, and we had reams of random people commenting on social media that Barilaro should be executed, that his daughter should be raped while he's tied up and made to watch, you know, that he's corrupt, that he's a piece of shit, all that kind of thing. And that is Exhibit A for proving serious harm to reputation. So you need to capture all of that. And often, if you don't capture it at the outset, the opportunity is lost because this stuff gets deleted. The next comment is not actually a requirement of the Act, but it's a best practice thing. If the plaintiff is not identified by name, you should give particulars of identification. Identify why he or she was reasonably identifiable in the publication and name some people who read it and knew that it was talking about the plaintiff. You won't be invalidated if you don't do that, but equally you could hardly expect the publisher to give your concerns notice a very favourable reception if you don't. The next one is also not, I suppose, as the Act has so far been interpreted, a statutory requirement, but in my view, it's necessary. If you're complaining of more than one defamatory matter, you should identify imputations for each matter complained of. You shouldn't just say, here are 5 publications, and then allege that collectively they conveyed certain imputations. Now, the District Court disagreed with what I've just said in 2 cases, one called Nyasulu and Nikalekale, and another one called Georges and Georges, where Judge Aberdeen followed what Judge Gibson had said in Nyasulu. Neither of those have been appealed, but with respect, I would suggest that's not correct. If you were to plead a statement of claim in that way, without identifying imputations matter for matter, it would be struck out. It wouldn't be compliant with the pleading rules. The purpose of a concerns notice is to give the defendant notice of how the case is going to be put if proceedings are commenced, so why should you do it any differently? The other reason it's necessary is because a defendant can make amends to individual imputations. That's an option they have under Section 15 of the Act. How can that be done unless the plaintiff has been specific about which imputations are carried by which matters complained of? So, as much as the District Court has suggested that it's not necessary and a cumulative approach is acceptable, I would strongly advise anyone against doing that. And you should definitely stick to doing it for each individual matter complained of. Now, when it comes to identifying serious harm in the concerns notice, this is likely to be the trickiest part of the process. Serious harm is an element of the cause of action under Section 10A of the Act, and what that requires is that the publication of the defamatory matter has caused or is likely to cause serious harm to the reputation of the plaintiff. So this is not a tutorial about how to prove serious harm, but I'll just note the following things about how to identify it in a concerns notice. The first is that what you need to explain is why the publication of the matter caused or is likely to cause serious harm. And that means you need to focus on how the matter was published and to whom it was published. So a classic example of that, I suppose it's too soon to talk about classic examples, but a good example of that is the first case that was decided about the concerns notice provisions, which is M1 and R1. M1 was R1's ex-husband, and R1 published some emails to their mutual child's child psychologist, which made some statements which M1 considered to be defamatory of him. He served concerns notices. He was self-represented, I should say. He served concerns notices which alleged that serious harm that was likely to be caused by the publication of these imputations was that they could compromise some unspecified work that he was doing in the education sector, Now, the problem with that allegation is these emails were published to one person who was a child psychologist who clearly had patient confidentiality obligations. So how were these imputations, defamatory as they may be, ever going to come to the attention of education authorities? There was no rational connection between the circumstances of publication and the serious harm that he had identified. Secondly, you can't just rely on the fact that the imputations are really, really bad. That's relevant, but it's not sufficient. The UK Supreme Court talked about the bases on which you can infer that serious harm has happened in Le Show and Independent Print, which is, I think, still the leading English authority. And it can be inferred from a platform of facts, including the seriousness of the imputations, the breadth of publication, the identity of the people who it was published to. But the seriousness of the imputations alone isn't good enough. You could satisfy the requirement either by proving that serious harm has already occurred or by proving that it's likely to occur in future. But as a matter of drafting practice, I would suggest that you distinguish between the two. And very importantly, and I think poor Jackie has to deal with this all the time when she gets inquiries, is that serious harm means serious harm to reputation. So your plaintiff might be very upset. Their feelings may be badly hurt by the publication, but that doesn't matter. It's not evidence of serious harm and there's no point particularising it. The requirement to inform the publisher of the harm that you consider to be serious harm is, I would suggest, poorly drafted, and it's ambiguous. The question that arises, I think, is whether that means you need to identify particular things that have happened, like my wife left me, I lost my job, things like that, or if what you're required to do is particularise facts from which you will invite a court to infer that there has been serious harm. My own view is that the latter approach is the correct approach. If your wife did leave you because of the publication of the defamatory matter, that is not in itself harm to reputation. You don't, in a defamation case, you don't get compensated for loss of consortium, for example, or for the economic loss caused by the loss of a job. What you get compensated for is damage to your reputation. And so the fact that your wife left you may be a basis on which a court could infer that there has been reputational damage, but it's not reputational damage in itself. So I think what you need to focus on is identifying and particularising a series of facts from which that inference reasonably arises. And similar to the point I made about imputations, my own view is that you need to identify serious harm separately for each matter complained of. Once again, the Court of Appeal has said, the District Court has said no in those same two cases, Nayasulu and Georges. The judges in those cases were of the view that it was good enough to do it cumulatively. That is directly contrary to at least 3 Court of Appeal authorities I'm aware of in England. One Court of Appeal authority and 2 trial authorities in England that reject that approach. And the District Court didn't deal with those English authorities in either Nayasulu or Georges. And whether or not it's strictly required legally, I would strongly encourage you as a matter of best practice to do serious harm individually for each publication. You need to attach copies of the matters complained of to the concerns notice. And if you are intending to seek an abridged period of time for commencing proceedings under section 12b(3), I would encourage you to notify the publisher of that intention in the concerns notice. Tell them why you intend to do so and invite them to consent. It's not a requirement, but you're putting them on notice, so they can't claim that they're taken by surprise. And if you do that and they say no and you win the application, it's a good basis for claiming costs. Now, I'm not here to tout for work, but the overarching piece of advice that I would give is you really ought to consider getting a concerns notice settled by counsel. If you would have the pleading settled by counsel, it should certainly be settled by counsel. And in an important case, you should consider getting it settled by senior counsel. And the reason is because, as we've seen, the way you draft the concerns notice can tie your hands when it comes to pleading the statement of claim. And if you stuff it up, it can get you struck out as well. Or summarily dismissed, I should say. It is a significant area of risk for practitioners representing plaintiffs. And as frustrating as it is to say, because this is supposed to be a procedure for quick, cheap and informal resolution of disputes, the prescriptiveness of these requirements means that it really is hard to avoid the conclusion that you need to treat them with a similar level of care to the way you treat pleadings. Now, what if you are a defendant and you get a concerns notice which you think looks a bit dodgy? My overarching advice would be that you ought to distinguish between a concerns notice which is defective in that it doesn't comply with the requirements and a concerns notice which merely discloses a bad case. If it is the former, it may be appropriate to consider some kind of application to deal with the fact that it doesn't comply with the requirements. But if it is the latter, the better approach I would suggest is either to seek to challenge the pleading or to seek a separate determination of, for instance, serious harm under the procedures in Section 10A for that to be done. I have to say that the authorities so far haven't always been careful with respect in drawing this distinction. In the Randall and McLaughlin case, I think that's a particularly striking example of that. The plaintiff gave 4 reasons for alleging serious harm in the concerns notice. The first was said to be the serious nature of the imputations. The second was that they concerned her professional reputation as a school principal. The third was the grapevine effect, that is the likelihood that it would be republished to third parties. And the fourth was that the plaintiff worked in a small community, that Dubbo, and allegations of this kind would be expected to be disseminated widely in that kind of community. And that was held to be inadequate particularisation of serious harm in the concerns notice, such as to render it invalid. They're certainly very scanty particulars, and it could not be said that the plaintiff's case was a strong one. But the difficulty with saying that they were invalid, in my view, is that on the authorities, including Lachaud, which has now been followed by the Court of Appeal in Rader and Haynes, that is a cogent basis for drawing an inference of serious harm. They are facts which rationally support the inference. That doesn't mean a court would necessarily draw the inference or that it's a strong inference, but it's cogent legally. And so my own view is that it's inappropriate to summarily dismiss proceedings on that basis if it particularises things which cogently support the inference. The plaintiff's case should be determined on merits. If you are dealing with a genuine case of inadequacy, though, the defendant really ought to follow the procedure for requesting further particulars. Perhaps Jackie could go to the next slide. There are reasons why a defendant might not want to do that. I could well understand why a defendant would say, I don't want to tell the plaintiff what's wrong with their case and give them an opportunity to fix it. and I want to preserve the tactical option to seek to have the proceedings summarily dismissed because the plaintiff stuffed up the concerns notice. But Judge Aberdeen considered this in the Georges case that I've referred to already. The plaintiffs in that case issued a concerns notice. It, if I may say so, was not a very good one, but the defendants didn't raise any objection to it and proceedings were commenced. And then after proceedings were commenced, the defendants sought to summarily dismiss the proceedings. Judge Aberdeen's attitude to that, which I agree with, I must say, despite the fact that I was acting for the defendants in that case, is that a publisher really has an obligation to act reasonably and mindfully of their obligations under the civil procedure legislation. And it's not really satisfactory when the Act provides this procedure for a publisher to sit back and say, I'm not going to raise this issue, and then seek to spring it on the plaintiff once it's too late. It's not in keeping with the purpose of the concerns notice regime, and it's seeking to take advantage of a technical defect in the plaintiff's case, which is not cricket. The point of the further particulars notice, as Judge Aberdeen noted, is that it keeps the offer to make amends process alive. It keeps the parties talking, and it continues to promote non-litigious resolution of the dispute. And that's why courts are unlikely to encourage defendants to adopt the sneaky approach and simply sit back and let the plaintiff walk into the trap. Now, of course, this assumes that the defendant is legally represented at the concerns notice stage, which won't always be the case. I can imagine that it might often be the case that a defendant doesn't engage legal representation, if they're not a media company, for instance, until proceedings are commenced. And so a self-represented defendant may not meaningfully have the opportunity to seek further particulars. And in Georges, the court did recognise that there may be cases where the deficiency in the concerns notice is so irredeemable that it's invalid despite the failure to request further particulars. But generally speaking, the risk you run if you don't engage with this process is that the court will take the view that actually you understood the concerns notice perfectly well and you didn't think you needed any further information to engage in the offer to make amends process, and the court's unlikely to entertain your objections. Now, I want to wrap up by posing the question, is this working, or is it all a waste of time and costs? And you can probably guess my answer to that question by the very fact that I'm asking it. The stated purpose of these amendments, if you look at the second reading speech and the explanatory note, was to avoid litigation, and it was to strengthen the concerns notice and offer to make amends process by ensuring that plaintiffs couldn't dodge the process and ensuring that publishers had enough information to decide whether or not they were going to make amends. That's all very well, but it's rather difficult, I would suggest, to see how the amendments which have actually been passed really serve that process, those objectives. In my experience and in the experience of my colleagues, it was never common for plaintiffs to commence proceedings without issuing a concerns notice. You'd be mad as an individual to sue a media organisation without trying to resolve it non-litigiously first. And if the plaintiff did commence without a concerns notice, there was probably a good reason why, such as urgency or the fact that the defendant couldn't be located. More seriously, I would suggest, why does the need to strengthen the amends process justify depriving the court of any discretion to excuse or cure defects. It's all very well to set out prescriptive requirements, but the legislation doesn't only tie plaintiffs' hands, it ties the court's hands too. And the fact that there is practically no scope to fix a defect after it's locked in means that the concerns notice process is do or die. And that means that plaintiffs need to treat it like a pleading, and they need to incur substantial costs in order to ensure that they comply and they don't get summarily dismissed at the first hurdle. And that's not only a problem for plaintiffs, because as a defendant, in order to make a valid offer to make amends, you have to pay the plaintiff's costs. And if the plaintiff's costs are higher because they've had to comply with all of this, those costs get passed on to the defendant. So, perversely, for a suite of amendments which are intended to promote non-litigious resolution, they in fact have the tendency in many cases, I would suggest, to make that more difficult. It'll be interesting to see what happens with the appeal in Newman and Whittington, whether that clarifies any of these problems. But I think the experience so far, speaking as somebody who's been in a lot of these cases and often on the losing side, is that these provisions are not proving to be workable. And ultimately, I think further law reform is going to be required to address these matters. Now, that's all I have. I'm happy to take questions if anyone has. Jackie has questions.
It's a question from our online audience. From a person called Chen. I'm wondering whether the content has been published on the media to be recognised as defamatory. What if someone spreads some fake and humiliating information by text messages?
So that is a good cause of action for defamation, as good as publication in the media. The way publication is defined in defamation law is it's a communication of information to a third party. So if you publish it to one person in text message or even orally, that is publication for legal purposes just as much as something which appears on the front page of the Sydney Morning Herald. As a procedural matter, however, if you're dealing with small publications like the kind that you're suggesting, you need to give more details, both in the statement of claim, but I would suggest also in a concerns notice, to identify who received the communication and when they received it. So if something's published on the front page of the Sydney Morning Herald, or it's a broadcast on Channel 9, a court will be quite happy to infer that many thousands of people saw it. But if it's one of these small-scale publications like your example, a court won't be prepared to make that assumption, and you'll need to give particulars identifying the people who watched it or listened to it or heard it. Any other questions?
I've got one.
Yeah.
So this is in response to responding to formal issues in a concerns notice. Now, we had an inquiry with an absolutely woeful concerns notice, it just said this is a concerns notice, and then it goes on to explain, you've hurt my feelings and all these things. It was so deficient in every aspect that it missed so many points of formal requirements that the question was, well, what are the particulars? Or particulars of substance or form? Do you need to request for the particulars? Is this a concerns notice pursuant to the Defamation Act?
You're the defendant in this case.
Yeah, it would be the defendant. Yeah. It is so defunct that had it been brought before a court, you would have very strong grounds, I would have thought.
Yeah, so...
Should you respond?
Yeah, as I noted in George's, the court did recognise that there are some cases where the concerns notice will just be so obviously deficient that it can't be allowed through to the keeper.
Yeah.
What I would suggest in a case like that is you write to the plaintiff and say, refer to your letter. Our position is that your letter is not a concerns notice within the meaning of section 12A1 of the Act. It does not do X, Y and Z.
Cover your costs.
We consider that we haven't been issued a concerns notice and we regard the matter as closed. The need to issue further particulars, in Georges, the court said it really arises where the plaintiff has had a stab at it and they've done something which is sort of moving towards the requirements, but they don't quite get there. In a case where they're just way off the mark, I think you're entitled, and this is what I've done in previous cases, to say you have not issued a concerns notice, we consider the matter closed. And then it often has the effect of promoting further discussion where the plaintiff tries to establish what they've done wrong and they'll probably have another go.
Yeah.
I should say also, as a practitioner acting for a plaintiff, what sometimes happens in my practice is somebody comes to me with a obviously deficient concerns notice, and it can be quite embarrassing for the instructing solicitor because they've produced this piece of work, charged the client for it. Often the 28-day period has passed and the solicitor comes to me wanting a statement of claim drafted, and I have to say, hold on, you haven't even done the first part right. And it's a relationship management issue. The way I have gotten around that in the past, smooth things over, is you sell it to the client as a final letter of demand. You can't use a draft statement of claim as a concerns notice, but there's nothing wrong with attaching a draft statement of claim to a letter which is a concerns notice. And so what I've done in the past is write a new concerns notice which hopefully complies, attach a draft statement of claim to that concerns notice, explain to the client that we have drafted a statement of claim and this is a final letter of demand, but you have to wait 28 days. And I think that's probably the best you can do to smooth things over in that situation. Any other questions?
Yeah, I have one.
Yeah?
What happens if this concerns notice is not in English?
It has to be in English.
It has to be in English.
Well,
Because the recipient might not understand that it's a concerns notice.
no, actually, I answered that very quickly and I probably should think about it more. There are requirements in the civil procedure legislation or possibly the UCPR about court documents needing to be in English. If you commence proceedings, a concerns notice is something which ultimately needs to be attached to the statement of claim. So I think probably what you ought to do is write a concerns notice in English, have it translated into the relevant language and serve both versions. Because the court will want to see that you've issued a valid concerns notice when that time comes.
I meant more about the person drafting it. not that.
Oh, if the draft person doesn't speak English,
Yeah.
well, again, they'll have to
They'll have to just reverse.
they'll have to acquire a facility in English in order to commence proceedings. So I think ultimately it will need to be done in both languages.
And then what happens if, because you know how it says you need to attach copies in section 12A, subsection B, attach copies of it.
Of the matter complained of, yeah.
What happens if they've attached those copies, but they weren't translated into English? Is it still a concerns notice?
Well, there's nothing in 12A that says it wouldn't be if you attached untranslated matters. But again, I think it's part of the answer to this is maintaining a paper trail, and it would be sensible to serve translations and original language versions.
Yes, naturally.
Yeah, and you'll need to do that anyway when you commence proceedings, so you may as well do it now.
experienced the opposite, where they've just had their client literally translate it and annexed it to the same claim. And there's no capacity to actually even satisfy the court that the imputations do arise.
I mean, it would be, if your client spoke the same language, it might be difficult to say that he or she hadn't been given notice.
Yeah, but I don't really want to. I really don't want to admit to an imputation in the circumstance of I don't want to admit to any imputation, period. But especially in the circumstance of my client's going, well, I trust you about as far as I can throw you.
Yeah.
It's always risky.
Yeah. I did a CPD last year about defamation proceedings in foreign languages.
Yeah, you did. Unfortunately, I wasn't in Sydney at the point in time. Do it again. You can.
It's available on YouTube.
Oh, awesome, I'll watch that.
Okay, any other questions, or is that it?
No online.
All right. Thank you.
Thank you.
You've been a lovely audience.